Arrested for eating Taco Bell in your car. Tonight we break down what happened, the Florida laws at play, and the exact script that avoids a bogus loitering arrest without escalating. Listen to the first exchange.
After hours, okay, I understand, I see that you're eating, but the reason I'm out here with you for this is because we've had recent burglaries to the business, and we need to make sure that everything is properly done here at these businesses. The businesses are private property, especially after the businesses are closed. Does that make sense?
Can I put my window up and continue with my meal?
I'm going to say no. That way I can stay in contact with you until my supervisor gets here, because apparently you don't want to answer any of the questions.
Can I give you like 2 inches?
That's fine.
Deputies approach a driver eating in a closed business lot and immediately push for ID. They cite recent burglaries but offer no specific facts that tie him to a crime. In Florida, there's a difference between a consensual encounter and a detention. In a consensual encounter, you don't have to identify yourself or answer questions. Once officers detain you, they still need reasonable suspicion of a specific crime. Loitering and prowling is often misused here, so let's get precise. It requires circumstances that cause reasonable alarm for safety or property, and the officer must afford the person a real chance to explain and dispel that alarm. That is baked into the statute. If all they have is "you're here after hours," it's not enough by itself.
What's your name and badge number?
I'm Corporal Deputy Haynes. I'm Corporal Haynes, and my badge number is 612.
Okay.
Are you from here?
Can I put my window up?
No.
Can you eat my dinner?
No, because we're conducting an investigation now.
Can I give you like
Now watch how the tone shifts when the driver limits the window and declines questions.
You're gonna be satisfied.
Here comes the escalation line. We're conducting an investigation now.
We're conducting an investigation now. Because you're being uncooperative for no reason. You're in an empty parking lot with closed businesses. You're refusing us to give us any kind of information. We don't know why you're here. You don't know who you are. We're unable to identify you. So try to figure out who and why you're here.
Labels don't create lawful detention. Facts do. Reasonable suspicion must be articulable and tied to a crime, not just a vibe. If officers truly suspect loitering and prowling, the law expects 2 things. 1, clearly stated suspicious circumstances that would alarm a reasonable person. 2, a genuine opportunity for the person to identify themselves and explain their presence. Refusing casual questions during a consensual encounter is not obstruction by itself. Obstruction without violence in Florida requires the officer to be lawfully executing a legal duty. That hinges on whether a real detention is justified, not merely declared.
Taco Bell? Oh, you can see it. This is gonna be better for the video. You can see Taco Bell.
Is there a reason that you picked this parking lot, though? Are you from here?
It's right next to Taco Bell.
Are you from here?
It's right next to Taco Bell.
Are you from here? Like you couldn't go
I'll give you
home?
that one. I answered that one.
No, you didn't. Are you, like you couldn't go home?
I'm not gonna answer any of your questions.
Okay, you go for another supervisor. We wait for another supervisor, that's fine.
That's fine. And he's gonna tell me, or she's gonna tell me that I'm free to go. And you guys are gonna feel like idiots.
Pointing out a bag in a nearby restaurant isn't evidence of a crime. It's an observation. Trespass usually needs signs or an owner or agent telling you to leave. Closed business alone is not automatic trespass without those elements. And even when property is private, officers still need lawful grounds to detain. The driver stays calm, records, and declines questions. That matters for court and for credibility with a jury later.
This is the one who's probably gonna tell them to leave me alone.
doesn't want me to identify himself.
How you doing, sir?
Howdy.
What you got going on, brother?
I'm not going to answer any questions.
You don't answer any questions?
No, sir.
Okay, we know you parked at a closed business, right?
Can I show you?
Yeah, absolutely.
You're familiar with this brand?
No.
You would identify that brand as Taco Bell?
Okay, I see
Yeah.
the order ahead. Okay.
Yeah, see, you see the consumed Taco Bell in the bag?
Right, yeah.
All right, we're doing some detective work here, right?
Okay.
And if you turn behind you, there's a Taco Bell, and so
Right.
I drove from Taco Bell, and
Okay.
then I ate my Taco Bell,
Okay.
and I was in the process of eating my Taco Bell when I was
Right.
stopped by your officers. So, am I free to go?
Well, not right now. We're trying to get your information from you, sir.
What's your name and badge number?
It's Sergeant Baldwin. This is a closed business. It's considered loitering, prowling. You can't be part of that closed business if you're eating your food or whatnot. Simple thing is when they ask for identification, you're supposed to provide it.
Here's the irony that makes lawyers wince. They arrest him for not answering questions, then read Miranda. Listen to the rights they read out
Free to
loud.
go.
All right, I'm gonna start it.
Read more.
All right. You have the right to remain silent. Anything you say may be used as evidence against you. You have the right to talk to an attorney and have him or her with you now or anytime during questioning. If you cannot afford an attorney, one will be appointed to represent you. If any time you wish to stop talking or have an attorney present, all questioning will be stopped at your request. Do you understand these rights? Sir, do you understand these rights? I'm going to ask you one more time. Do you understand these rights?
I'm not going to answer any questions, man.
Step out of the car.
You have the right to remain silent. That right existed before the cuffs. Miranda just formalizes it after custody and before interrogation. If refusal to chat is the only obstruction, the legal footing is weak. Courts look for more than silence. They look for interference with a lawful duty, which circles back to the original question. Was there reasonable suspicion, and did the officers provide a real chance to dispel alarm? Here are your 4 takeaways for parked car encounters. 1. Mere presence after hours isn't enough for loitering and prowling by itself. There must be specific circumstances that create reasonable alarm. 2. Officers must give a genuine opportunity to explain before arrest on that statute. 3. Refusal to answer casual questions is not a crime in a consensual encounter. 4. Use the calm script. Officer, am I being detained or am I free to go? If detained, what specific crime do you suspect, and how can I dispel your concern? If free to go, leave calmly. If not, keep recording, stay polite, and save the arguments for court. Want our 1-page parked car rights script. It includes exact lines for window position, the 2 magic questions, and when to stop talking. Comment taco and we'll pin it for you. Laws vary by state, and this is educational, not legal advice. Stay safe, stay calm, and know your rights.